on venue.
So just a quick rundown for this week. So we are finishing our discussion of venue today, and then we'll talk about the form of non-convenience. And then on Tuesday, you have a homework assignment. I hate saying homework because you're not in college, but you have a reading assignment. Because what I want you to do is to go back and review everything you have covered thus far with respect to personal jurisdiction. So the different types of personal jurisdiction, long-arm statute, and so what I'm going to do is send you a what I like to call a personal assessment. I have to say it's a practice question because people get all wild out by it, but it's just assessing how well you are able to pull all the materials together. I mean, how well do you understand it? So a lot of times you might not understand it as well as you think you do. So I'd like to give you the opportunity to evaluate that before we move on to subject matter jurisdiction. So it's kind of like it's not graded, but I'll have a model answer. We'll go over it together in class. I just want to make sure that you know what we're doing. So any questions, and that'll be Tuesday. It takes an hour, and we'll give it an hour and 15 minutes to do the practice question assessment. And so I'm going to have you do that on your own time. So we won't physically meet on Tuesday, but because you're doing the assessment, I'll need you to at least turn in what you've done to me, to the LRC, anytime next week, just so I can use it for attendance purposes. And I'll basically go through them. And if I see any major red flags, I'll ask you to meet with me. Again, I'll still give you the model answer, but if I see someone I'm concerned about, and of course you're not required to meet, so I'll at least reach out and try to get you to come and meet with me so we can sort the puzzle out. Okay? All right. Is it me or was it flooring this morning?
Yeah.
Did it the forecast right? Okay, so I'm like a weather junkie, so I just want to be, when I was in college, I originally went to school to be a weather person. Thank you. That's what I could do it, And I had the personality like a funny, cool weather person. So I took meteorology, which was required. And what do you think I got in that class?
A. B.
D minus. Okay, so really the professor liked me, and I just think he didn't want to fail me. Basically, that's failing. It was so freaking hard. Because I'm like, how hard is meteorology, right? So I just thought you got to put on a cute outfit, talk about the weather. I didn't understand that they're actually scientists. Just happen to be good-looking people, right? So, and I don't hate science, but I'm not passionate about science, nor did I like it in high school. And so I didn't realize how much science was involved, and I just bombed it. And so then I had this crappy D minus on my transcript. So Florida State has a forgiveness policy, which is rare. I don't even know if they still have it, but you can retake 2 classes, and they'll completely wipe it off your transcript. The highest grade stands, which I think is awesome. And so I retook it with a tutor, and still just got a B, like with a straight up every week tutor. That's how hard it was. So I realized that was not my calling.
Engineers.
Really?
Yes, they have to be.
See, you didn't know that either.
I didn't know that either.
Actually,
People can't
Yeah, so just out of curiosity, before we jump into class, if you could be anything in the world besides a lawyer, what would you do?
Okay, 3.
Ballerina. Actress. So I think what I would have done if I could do anything, and don't judge me, okay? I would have been a physician. This is awesome. I didn't realize how much money they make. Yes. It's incredible that these people live like this. And so, no, it's just very doctor. Like literally, ER physicians make, which blows my mind. Like they're bring home, so the taxes are out like $38,000 a month. Like, isn't that outrageous?
Yeah, that's crazy.
That's a lot of freaking money. And then the cardiologists and the surgeons bring home like 52, 51,000 a month. Like what do you do with that much money?
They got to after loans. We think 3 years of loans is bad.
But even still, like that's just incredible to me. If I had known then what I know now, honestly, I would have taken the tutors. I would have gone. I forgot about it. But that's fine. All right, so let's get started. Yay, we are ready to rock and roll. I'm bored out of my mind with college football. You can only watch so much. All right, so let's start off with just a recap from last class, just to make sure you remember the highlights. Okay. So last class, as you remember, we began our discussion of venue. We took the rules, or took a look at the rules of 1391B, which are our core venue rules. We also reviewed section 1404 and 1406, A for both of those. And you use those again when you're challenging venue. So again, 1391, you're trying to establish where is a proper venue. And again, just remember, venue just means where within the state of Kentucky can I file my case? Which federal district court? Western, Eastern District, and so on. And if you don't like where the plaintiff, you're the defendant, and you don't like where the plaintiff has chosen the forum, meaning where within the state they want to file, you can challenge that through section 1404 or 1406, meaning you're either trying to get the case thrown out or transferred to a better venue, so a different federal court. I also mentioned in our online class, just a reminder, that with venue, you can only transfer within the same judicial system. So from one federal court to another federal court. You can't transfer from a federal court to a state court system. So when we talk about subject matter jurisdiction, what that tells you is whether you can file a case in state court or federal court or both. Okay, sometimes depending on the fact, you can file a case in either state court or federal court. Other times you only have one option. And so if by some chance you feel that the case should not have been filed in federal court, it didn't meet the requirements, that's when you would challenge venue as well and say, no, this should be in state court. And again, remember I said at the beginning of the semester that all of this stuff is like a big elaborate chess game. It's strategy. If I'm challenging a plaintiff who's filed a case in federal court and I want it in state court, it's because I think the state court is going to be a lot more amenable and favorable to my case because I am Comfy Cal, I'm a local business, and so I know that the judge who's going to be a state court judge who has to be reelected, he or she's not going to want a bad reputation for letting some city slicker from New York come in and screw my business over, right? Local businesses. So I want it in state court. So if there's a way I can challenge venue when someone's filed a case against me and trying to make me litigate that case in federal court, I'm going to use these statutes to do that. Okay. How do you assess whether a plaintiff has filed their claim in the appropriate court, district court? Remember 1391B provides that three ways of deciding whether or not it's in the appropriate court. And again, when I throw out these numbers, you just Google Civil Procedure Rule 1391B and it comes up. Whatever rule you see in a case, if you Google it, it comes up. So 1391B provides one venue is appropriate in any district where any defendant resides if all the defendants reside in the same state. So that's what we covered in the last class. So I'm not going to spend a whole lot of time on it. Plus it's in the slides that I sent you. Second, another way to satisfy venue or see if it's appropriate is venue is proper in a district where a substantial part of the events or ignitions giving rise to the claims occurred, or where a substantial part of the property that is the subject of the action is located. So we're going to see that in the Piper case, right? So, if there's a plane crash, and you're saying that Delta didn't do their due diligence in terms of maintenance of that plane, even though I may live in California, the crash happened in Florida. So, it makes sense that venue is probably going to be more appropriate in Florida because we're going to need our experts to go into the plane wreckage, the people that, were eyewitnesses to the plane descending from the sky with their iPhones, and, where they saw the smoke trailing from, and so on. So, That's a second way to establish whether or not venue is proper in the court they chose. And then lastly, remember section 3 is kind of like that catch-all, kind of if 1 or 2 doesn't apply, then 3 is where you go. So 3 says when no district anywhere in the United States satisfies either of the 2 venue choices, meaning 1391 B1 or 2, venue is proper in any district in which any defendant is subject to the court's personal jurisdiction. So that just means if 1 or 2 doesn't apply, which typically is, I mentioned in our last class, is because it's someone who's an international, it's an international case. Any district where the defendant has personal jurisdiction. So say if there are 3 defendants and Kentucky has personal jurisdiction over me, another one of the defendants is a resident of Indiana, Kentucky doesn't have jurisdiction over them, but they do have it over Indiana, you can pick either state. So it's just a catch-all. It says we need to find somewhere where venue is appropriate if 1 or 2 doesn't apply. So it can be where any defendant resides, where any defendant, where the state has personal jurisdiction over that defendant. So that means they have contacts with that state that are significant enough to justify personal jurisdiction, whether it's through general jurisdiction, substantial contacts, meaning someone from London got hurt at McDonald's, well, obviously all 50 states, McDonald's going to have substantial contacts through general jurisdiction because they have such a strong presence, they're essentially at home in all the states, so you can basically pick what state you want to file a case in. Okay? So any questions about that before I move on, because I want to make sure that you understand it. All right, so how do you assess residence for the purposes of venue? Section 1391C, just a reminder, and again, we covered this in the last class, but because it was online, I just want to make sure you didn't miss anything. So again, how do you assess residence for the purposes of venue? That's based on 1391C. Essentially, you're deemed to reside in any district where you're domiciled, okay, where you're domiciled. A business entities are deemed to reside in any district where the corporation would be subject to personal jurisdiction. So again, if you're a person, if you're trying to figure out where you reside for venue purposes, meaning do all 3 defendants reside in Kentucky, you're going to look at where they're domiciled. And again, I mentioned domiciled is their place of abode. And again, I mentioned that can be tricky, but you're going to look at the facts and say, Professor McNeil works in Kentucky. She has a home in Kentucky. She has a Kentucky driver's license. So you're making your argument why I'm domiciled here in Kentucky. So again, that's one of the ways you determine residence, looking at those types of factors. What address do they use when they file their taxes? I mentioned as well. But for businesses, it's any district where they're subject to personal jurisdiction. Okay. And so, what if you're dealing with a defendant that does not reside in the United States, including a defendant who's not an equal in the United States, where he may be sued, and essentially any defendant not residing in the U.S. may be sued, just like the catch-all, in any judicial district in the U.S. So it's pretty much the sky's yours if you are not residing in the U.S. and you're not a citizen, you just pick a district. Okay. How can the defendant challenge venue? I mentioned they can file a Rule 12 motion and say I want to challenge venue because it's improper. And so we'll spend a whole class on Rule 12 motions, but essentially there's a document that all the law firms have, their motions, and you kind of fill in the blank why it's improper venue. When you file that motion with the court, you'll show up for a hearing, and you'll kind of do your oral arguments based on the written motions to the judge and say, this is why this venue is improper, Your Honor, blah, blah, blah. The other side will say, the plaintiff, no, I picked this venue because of this, it is proper, and the judge will make a decision. So that's essentially how you challenge venue. So you either file that Rule 12 motion, or as a defendant in response, when you respond to the complaint, the charges that have been alleged against you, and again, we'll talk about that further down, you can challenge venue there as well. So you can either do it by motion, or challenge it in your answer to the complaint that was filed against you. And when you're answering a complaint that's filed against you, essentially they're saying you were committed negligence by McDonald's by not properly keeping the floor dry and safe, and in your response to the original complaint, when you're starting the process with that complaint, your lawyer's going to say, no, this isn't true, the area was clean. Actually, we have eyewitnesses that will attest that we saw the plaintiff pour their soda on the floor and then proceed to fall, right? So we're basically being set. And so in that response to the complaint, you can challenge venue. The reason I use that example is I mentioned earlier that we had a neighbor in California that made a living off of intentionally falling. She would see a yellow thing, she would like literally scope the grocery stores where they put up the yellow caution thing, and she would move it and then fall. And then say she had to go to the chiropractor.
I'm just curious, I don't think it's related, but would they be able to, defense be able to bring out the fact that she's been involved in like
multiple lawsuits, absolutely, but even if you have, it's a character issue, but when you got doctors, there's so many shady doctors that will, serve because they get paid just to come in as a witness, expert witness, and say, oh yeah, her injuries are pretty expensive when they're not. But yeah, she drove a really nice car. I was really envious of her. So I'm like, she doesn't even work, Mom. It's not fair. Her kids have this, and my mom was just like, she'll get hers, but I never saw her living a life. You know, it's like when people cheat, like if you're on a sports team, you're like, they totally, and they're like, oh, they'll get theirs. That's not really true. It's not. When you think about it, I feel like they totally cheated, but it's okay. She cheated. And I mentioned to you, I just want to make sure because it's important, and I promise you, I will ask you this on the exam. I tell everybody this every year. Still, not everybody gets it right. I'm going to tell you again. I'm going to ask you the difference between section 1404 and 1406 because you need to know the difference between the two. So just as a reminder, 1404, again, you're trying to transfer venue, right? You're challenging venue. 1404 applies when the plaintiff has filed a claim in the correct forum, so they're in the correct forum, right? And it only permits transfer for the convenience of the parties or in the interest of justice. So again, 1404A, the original venue chosen was proper, meaning it was proper based on 1391. But the court will transfer for the convenience of the parties and witnesses or in the interest of justice. The key is 1404A only allows for transfers, not dismissals. So you can transfer from the Western District of Kentucky to the Eastern District of Kentucky, but you cannot get the case dismissed and thrown out. And again, in making that decision, the judge will look at where's the evidence located, where did the accident occur, or the harm occur. It could be a breach of contract. So they'll look at all the factors, but again, it's basically for the convenience of parties or the interest of justice, and you cannot have the case dismissed. 1406 applies when the plaintiff chose the wrong venue from the beginning. So because they chose the wrong venue from the beginning, 1406A allows the judge to either say, you know what, improper venue, you should have known this, is obvious. I'm going to dismiss your case. You can go file the paperwork all over again, and you can explain to your client why there's additional fees to start this process all over again. Or you can eat the cost yourself. But this is ridiculous. I'm dismissing the case. Or they can say, oh, I'm going to go ahead and be nice, and I'm going to transfer it to the proper venue. So you're not at risk of having your case dismissed on 1404A, but you are on 1406A. All right. So I believe we did not. Yes.
For 1404, is it that both are agreeing to the transfer as well, or is it just like one says it's more convenient and they're asking?
No, because remember the plaintiff, initially they're going to pick what venue they think is best for them. They don't want to transfer the case.
Okay.
So it's the defendant that's doing it. Now, there is a rule that says if they both agree, all parties, after the case is filed, to transfer the case, then they can, without the judge intervention, but it has to be done within a certain number of days of the complaint being filed. But that's when we get later down the line. Okay, yes?
For 1404A, like the defendant wants to transfer out of convenience, but I've also read that it has to be like the venue that they're at that's appropriate is like unconstitutionally harsh towards the defendant. How would we know that in the fact pattern?
Where did you read unconstitutionally harsh? That's a very strong word. Is it a note?
Just out of like Piper, that
You don't define it, but literally, but so on Piper. So that was based on 1404?
yeah, that because Scotland has a judicial system, it's like international and not like.
Yeah, so your question, great question. So your question with respect to it has to be reach that constitutional level of scrutiny. It's really just the judge's assessment on fairness. It just goes back to that fairness prong, and it's subjective. So when you say how would you know, there's not really a way for you to know. It's just depending on which side you're arguing for, you're going to make that argument. But there's not they don't have a standard or criteria in place like with the international shoe case. We know these factors are what are considered. There's not a framework in place for that, unfortunately. I'm sorry, but great question. Anyone else? All right, so let's do the Thompson case. Yay. And we will do. Where are we here? Attorney Platt, am I calling you already? All right, let's Cole. Okay, all right, so you're done. And then your co-counsel can be Mr. Cannon. Are you good?
Yes.
Hi. All right. All right, cool. How did you log? You're just raise your hand a lot.
That is.
I forgot that quick. I called him Kelsey, right? Is it Cole? Is it past Cole? Yeah. Okay, same terms. All right, can you give me the facts, Kelsey, for Thompson, the Thompson case, please?
So the plaintiff purchased a ticket from Pensacola, Florida to Mississippi.
Huh?
And the ticket provided that he would arrive at 5:05 and they left and he took a nap and then missed his transfer. So then he is suing the bus company for not getting to where he lived because he was poor and got in trouble.
Okay, so when you saw these facts, what were you thinking?
He is a loser.
And I appreciate your honesty. So every time I see this case, I'm like, really? So you fell asleep and you're suing the bus company? Like, you really for a bus ticket? It probably cost you like what, $80? Like, is that worth attorney fees? Like, what's this guy doing? So yeah, so he purchased this Greyhound ticket from Florida to Tunica, Mississippi. Who's broke Greyhound at some point in their lives? Only a few. Poor souls. So I used to ride Greyhound before I got my first car. And when I got my first car, I said, I don't care if I have to walk from here. I will never get on Greyhound again. The bathrooms are always disgusting, and I always have creepy people sit by me that want to breathing on me. They have poor hygiene. They want to talk to me. And I'm just like, leave me alone. I hate Greyhound. I used to take it from Tallahassee to visit my family in Orlando. I hated Greyhound. Hate it. But anyway, so we know that he's on Greyhound, as she stated, Attorney Cole, and Greyhound bus delivered the plaintiff from Pensacola to Mobile, Alabama, just after midnight. 7 hours later, Greyhound personnel directed the plaintiff to board the Colonial Trailway bus, which is what he's upset about. And so the driver, defendant Terry Reeves, announced that the bus was traveling only to Jackson, Mississippi, and therefore returned to Mobile, and that a bus would depart for Jackson, Mississippi at 12:30 p.m. and arrive in Tunica, Mississippi at 5:05. But as Attorney Cole said, the plaintiff took a nap. So when the plaintiff woke up, he realized it was 2:30 p.m. and the bus was already heading back to Mobile. So the plaintiff had to wait 9 hours, which is pretty significant, in Mobile until his brother sent him a ticket back to Pensacola. So the plaintiff then missed his court date and was found guilty of abstention. So the plaintiff uses Greyhound, Colonial Trailways, and Reeves on several state law causes of action, meaning he files claims. And he says, yes, this case should be in this federal court because I have subject matter jurisdiction based on diversity. And although we haven't covered subject matter jurisdiction, again, it just means that the plaintiff and the defendant are domiciled in different states, right? And so he's like, I can have this case in federal court. So Attorney Cannon,
Yes.
What's the issue in this case? Why are we even here?
So Greyhound moves to dismiss because they say they failed to state a claim and that they don't that it was the improper venue.
Excellent. Okay, so you have a situation here where the defendant, Greyhound, is saying, hey, you picked the wrong venue, it's an improper venue, as well as failure to state a claim. So we'll talk about that later on too. But failure to state a claim typically is when you feel like the plaintiff's claim of what they're alleging isn't adequate, meaning it's not like this is kind of a goofy claim. Oh, I overslept and I want to sue you because I overslept. Like they're like this isn't even a legitimate claim essentially, right? So who has the burden then, Attorney Cole, of proving that this is a correct venue?
The burden is on the plaintiff.
Okay, and they're going to do that under 1391B, right? Okay. So again, the court essentially says that Greyhound, they criticized Greyhound for not requesting an evidentiary hearing. The plaintiff needed only to establish a prima facie case showing a venue. Because of the Greyhound failed to request an evidentiary hearing, the court's review is very limited in this complaint because neither party presented affidavits or evidence to support whether venue was proper or not proper. So we know that the court concludes that the plaintiff does not meet the standard for proper venue under, again, 1391B. Why does the plaintiff lose under 1391B, Attorney Cole? Well, B1 rather. Why does B1 not apply? I apologize.
Because he was a citizen of Florida, so he didn't qualify for residency.
Okay, so where are the other defendants' residents at? Or can you tell me where the plaintiff brought the suit at?
They brought it in the place where the transfer should have happened.
Which state was that?
Alabama.
Yeah, excellent. Southern District of Alabama. So we know, remember 1391B1 tells us what? What was that rule?
That you can have a venue where independent is resident in that state.
Excellent. So 1391B1, remember, venue is proper in any judicial district in which any defendant resides, and all defendants reside in the state in which the district is located. So all individuals reside in the U.S. district in which, again, that person is domiciled. We know the plaintiff brought the suit in the Southern District of Alabama, right? Reeves, as she stated, is a citizen of Florida, and his domicile residence is the state of Florida. So because of that, obviously, you cannot bring that suit based on 1391B1 in the state of Alabama. Now, if he was a resident of the state of Alabama or domiciled in the state of Alabama, as well as the other defendants, then yes, you could bring a suit there. But again, because Reeves does not reside in Alabama, is not proper venue under 1391B1. Attorney Cannon, what does the court say about the second option, 1391B2?
Okay, so that one's if a substantial part of the events that give rise to the suit happened there, they kind of, I think, brush that one aside because weren't they just like, well, you just changed buses there, so that's not enough to qualify as substantial.
Do you agree with that?
It's kind of hard to separate your opinion of like this guy's behavior
I know,
from the
facts.
facts, but
Wait, he's the Chiquita Banana case.
yeah,
Let's do that.
I feel like as dumb as it sounds, I mean that's kind of the basis of the claim is that he missed the transfer there. So I guess I don't agree with it. No, not in this case.
What do you think, Attorney Cole?
I think that it does have more to do with where he purchased the ticket because, I mean, they didn't have a duty to wake him up or do anything at that bus stop. So where they had to contact to like see where they have me.
Okay. But can you see the difference in how you would argue both? Because in one sense, I think Attorney Candace's argument is very strong. Because when I see this case, I'm like, that's where the breach allegedly occurred, or the incident was during that transfer. Yeah.
Well, wasn't that where he started, but then the failed transfer was in Jackson, Mississippi? You know,
But still, that's where he fell asleep.
did we know where the nap started? Then he crossed into Mississippi.
Good point. So we know that the only event that occurred based on the court's assessment in the Southern District of Alabama was, again, that the plaintiff changed claims there and that the event did not directly, according to the court, give rise to the claim. It wasn't alleged that the bus transfer led to a breach of contract, right? Greyhound's negligence and breach of contract arise from the failure to drive safely and successfully transport the plaintiff from to Tunica, Mississippi. So the way the court saw it is that the plaintiff entered into a contract essentially with Greyhound to get him to Tunica, Mississippi by 5 p.m. on March 15th, and taking the Colonial Trailways, but to Jackson would have gotten him there at the time, again, but he fell asleep. So just because he passed through the Southern District of Alabama forum and changed buses there, of course, it doesn't mean the claim necessarily arises out of that venue. But the court does something interesting in this case, right? Instead of dismissing the case, they transfer. Do you think they should have dismissed the case, Attorney Candace?
No, I mean, why not let it run its course? Like, I think they're probably pretty confident that it's going to get dismissed somewhere along the line, but they're like,
So why not now? That's my point.
well, I don't know. I mean, like, you've got this prong system set up. If you start messing with it, then, you know, like, just for the sake of it, because, yeah, it's silly.
It's
And
relevant. This is why our court docket gets overloaded with goofy stuff like this.
yeah, I know that's a good argument, but I'm in favor of just letting it run its course so you don't have to start tinkering with it. It's kind of like what we talked about with, like, the O'Connor versus that other test. Like,
Brennan?
yeah, just, like, let it run its course, and you've always got that fairness prong to back it up if you get there, but you don't need to, like, cut it out in the beginning, I don't think.
So you represent, and I'll give you a question, 50% of our faculty. So we sit every year and debate in faculty meetings about process, and how important it is to go through the process. And so some of us are like, why are we, like, let's just vote. Like, we'll have an issue. Why can't we just vote on the issue? We know we have an overwhelming majority. We know it's going to pass. Let's just vote on this new initiative.
Back it up if you get there, but you don't need to, like, cut it out in the beginning, I don't think.
So you represent, and I'll give you a question, 50% of our faculty. So we sit every year and debate in faculty meetings about process, and how important it is to go through the process. And so some of us are like, why are we, like, let's just vote. Like, we'll have an issue. Why can't we just vote on the issue? We know we have an overwhelming majority. We know it's going to pass. Let's just vote on this new initiative. But no, the process says we have to set up a committee. The committee has to meet. They have to draft up a proposal and come back and have a discussion about it. Well, we know what the outcome's going to be. So half of us are like, this is dumb. Like, it's a waste of our time. I don't want to be on the committee when we already know that we're going to vote yes. But the other half say, no, process. We have to there's a process in place to make sure there's transparency, fairness, because if we start allowing people to circumvent process for this, they're going to circumvent process for other things. And so there's always been kind of that bumping. Like, for instance, let's just say hypothetically, Shelley Santry was hired as an adjunct, right? She wasn't, but let's just say she was. We love Shelley. She's like rock star over there in the clinic. It's a lot of work, but she's an awesome professor and a pleasure to work with. So there's an opening that comes up in the clinic. We're like, hey, everybody loves Shelley. Her evals are good. Why reinvent the wheel? Let's just hire Shelley and keep it moving. No, we have to have a formal search and have a process. And that's what I mean. So he's someone that respects the process, right? Says, I think the process should be in place, but I guess my challenge is, I understand that, and I know it's dangerous when you start circumventing process, but my gosh, the docket is so backed up. Some people are waiting years just to hear their cases and get redressed because of goofy stuff like this.
Some people like to go through Congress, other people like to do these executive
Orders.
emergency orders.
Well, I actually just thought about it more in my head. So when you were saying that, I was just thinking, so why didn't the defendants challenge both, like the venue and the claim? But they did. That was
They did
right.
their due diligence.
Right.
Yeah, they didn't provide any evidence. They said, oh, failure to state a claim, but they didn't provide any evidentiary basis. Meaning you have to say this is why this claim is not sufficient and it's a waste of the court's time. It's not a legitimate claim, and so they didn't. That's why the court's just like, we'll just address venue. I don't know why they didn't. That's the only thing disadvantage about these cases. Sometimes you can't see behind them.
That's what I was going to ask about, because it mentions that they didn't request an evidentiary hearing. It says they didn't file any affidavits or anything. So if they had, is it possible that
Yes,
they could have
absolutely.
had
They
dismissed?
could have been dismissed at this level. I don't know why. Yes.
How could
You
they
moved. Yeah, I just realized why. I was like, wait, what are you doing? Yes.
How could they dismiss it though if they don't have the authority to because it's in the wrong venue?
Right, and that's a good point too. So she was saying, and she remembered the distinction. How could they dismiss the case if it's in the wrong venue? Because remember, we only dismissed with 1406, but not under 1404. So their only option was to transfer to the proper venue. But they could have got the case dismissed under that failure to state a claim if they had pursued it. They should have. Okay, pursued it. All right. So where are we? So we know instead of dismissing the case, the court elects to transfer. As stated, a substantial part of the omissions and events giving rise to the plaintiff's claims occurred in the Southern District of Mississippi. That was the court's assessment. Reeves driving a plaintiff to the Southern District and not waking him up in Jackson. Colonial Trailways operation. Their bus in Greyhound, sell ticket. Everything happened in Mississippi. So under 1406, again, where venue is in the wrong division, the court has the option under 1406 to dismiss or transfer the case. In terms of 1391B3, right? 1391B3. The reason the plaintiff cannot use that particular section is because venue can't be established under 1391B2. So if one of those first two options are available, you cannot use 1391B3. So the whole important takeaway from this case is just showing you how what it looks like when someone is challenging venue as being improper, how you go through the steps and see whether 1391B1 or B2 is applicable, and kind of what the court's rationale is in deciding these decisions. And so it's just like for the rest of the semester, what we'll be doing is you're going to have a rule, and the case is just showing you what the rule looks like in practice. Okay, so it's just provide you an example. So before I transition into the forum or the doctrine of non-convenience, any questions about 1391? Because we're not going to come back here in a couple of minutes. All right. So the judicial doctrine of form non-convenience. So it's essentially a Latin phrase, as you can tell, that means surprisingly the form is not convenient, right? I already got that right on the outset. That was pretty easy. So what's the difference then between this doctrine of forum nonconvenience and section 14A, right? Because obviously they kind of look like the same thing. So section 1404A does not permit dismissal of the case. It only permits transfer of the case from a proper forum to a more convenient forum. So again, the difference between the doctrine of forum nonconvenience and section 1404A is that section 1404A does not permit dismissal of the case. So section 1404A does not permit dismissal of the case. It permits only a transfer of the case from a proper forum to a more convenient forum. So again, 1404A does not permit dismissal of the case. It only permits transfer of the case from a proper forum to a more convenient forum. On the other hand, the doctrine of forum nonconvenience, the court may dismiss the action because the forum is inconvenient. Right? That's pretty big. Do we like this doctrine? Just because it's inconvenient, don't dismiss my case. Yeah. So again, under the doctrine of forum nonconvenience, a court may dismiss an action because the forum is not convenient. The catch is that a greater showing of inconvenience is required for a forum nonconvenience dismissal than for a convenience transfer under section 1404A. So again, the standard of proof you have to provide of showing a level of inconvenience is much higher if you're going to use the judicial doctrine of forum nonconvenience to dismiss a case, as opposed to under 1404A, if you're just trying to transfer for more convenience, you don't have to have it as high as the standard. It doesn't have to be as egregious. So if you feel like it's blatantly obvious that this case should be dismissed, like again, I use a plain example, everything is obviously in Florida witnesses, the plane wreckage, you would do the judicial forum nonconvenience. If it's not that cut and dry, it's a Burger King situation between Michigan and Florida, then you might want to try section 1404, right, to transfer the case. All right, so some examples of forum nonconvenience. In this instance, why the court dismissed rather than transfer the claim. The court dismisses because it cannot transfer, right? Because a more appropriate court is in a different judicial system. So that's one of the reasons you would use the doctrine of forum nonconvenience. It's because the appropriate court that it should be in is a different judicial system. So say they realize the court was filed in federal court, but really the case should have been filed in state court. Well, because you can't transfer between different judicial systems, the court has no choice but to just dismiss the case, right? So that's one of the reasons. So an example would be a case is filed in a proper state court in Alabama. The state court of Alabama has personal jurisdiction, subject matter jurisdiction, and venue is proper, right? But the Alabama court, but it makes more sense, for the litigation to be heard in Florida. So even though, again, in Alabama state court, personal jurisdiction is proper, subject matter jurisdiction is proper, venue is proper, it makes more sense for the litigation to be held in Florida, which is what we'll discuss in the Piper case. The Alabama court cannot transfer to Florida, the Alabama state court, because they're a different judicial system, right? So if it's showing is strong enough, the Alabama state court will dismiss the case under this doctrine of forum nonconvenience, all right, and permit litigation in Florida. They will dismiss the case. If the case had been filed in a federal court in Alabama, then would you need to use the forum nonconvenience? And the answer is no. Why? Because if they had filed the case in the federal court in Alabama, that's fine. You just need to transfer it to the federal court in Florida. It's still within the same judicial system. Okay? Does anybody not understand that? All right. So let's see what this looks like in practice. So the Piper case. Mr. Cannon, Attorney Cannon, if you could give us a fact. Well, actually, tell me who the plaintiff is first in the Piper case.
I love this word, I'm going to botch the pronunciation. Is it the testatrix of the estate of the deceased?
Yeah, can you put that in layman's terms?
Like the person that's administering the estate.
Yes, excellent. You did pronounce it correctly. All right, yeah, so it's not the heirs, right? It's not the heirs and the next of kin of the Scottish residents who died in the plane crash. It's actually, because none of them are named Reno, the plaintiff, as he stated, is the administrator, right, of the Scottish decedent's estate. So basically the lawyer's administrative assistant. She's the plaintiff, and so she's basically filing a suit on behalf of the estate. That's how estate suits work. We know that the decedents in this case are Scottish. Who's the defendant, Attorney Cannon?
The defendants are the manufacturer of the plane and the manufacturer of the propellers, and the Scottish, I think the Scottish taxi service that owns and maintains the plane is included.
Yes, okay, so we have Piper Aircraft, right, is one of our defendants who made the plane in Pennsylvania, and just the second one, not the taxi, and Hartzell, who made the propellers in Ohio, okay, so those are our defendants. So since forum nonconvenience is all about assessing whether there is a more convenient forum, let's break the facts down and associate them with the specific location and space, okay? So what did the facts state occurred in Ohio, Attorney Cole? What occurred in Ohio?
Just that they manufactured the propellers.
Excellent, so all we know is that defendant one, which is Hartzell, manufactured the propellers in Ohio, so that's the only thing that happened in Ohio. What about Pennsylvania, Attorney Cole?
That the engine.
Okay, see how this is getting convoluted already. So we know propeller created or manufactured in Ohio. The actual plane was manufactured by Piper in Pennsylvania. What happened in Scotland? The obvious, the crash, right? It's operated by a local company. The problem is there were no eyewitnesses, but all the decedents, heirs, and next of kin are Scottish, right? And the plane was subject to Scottish air traffic control when it crashed, and we have a Scottish pilot. It's really not good. All right, so Attorney Cannon, where was the airplane registered, maintained, and owned?
Okay, yeah, so that was for McDonald Company. It was
What
in
country?
Scotland.
Sure.
Oh. Cool.
UK.
Oh, sorry, right.
Sorry, Attorney Cole. So we know that the plane was registered, maintained, and owned in the UK. Airplane, and then what else was in England? The obvious, the wreckage, right? Was in a hangar in Farnborough, England. The British Department of Trade investigated the crash, looked to see whether or not there was mechanical failure with respect to the airplane, engine, or the propeller, and they also looked to see whether or not there was pilot error, right? Which probably was the cause of the crash. There was no evidence of defective equipment. So there are a lot of different locations that are associated with this plane crash, which would be kind of a litigation nightmare. So we know the plaintiff finally initially filed a suit in California State Court, right? And then where did it go from there, and how? What did the defendant do? Attorney Cannon.
Yeah, I think it was, I'm trying to remember who was first. I think Piper moved to transfer it to the Middle District of Pennsylvania, where they have,
We moved it to which federal court?
third, no. California, sorry.
And
No.
so Nora's like horrible control. So, I've seen people help their colleagues. I'm totally fine with it, but they're like real smooth with it. She goes,
That's right, I have it right here too. I don't know why. Yeah. Okay. Yeah. It's the Federal District Court in California invoking diversity jurisdiction.
Okay. So yeah. So essentially, plaintiff says, I want this case in California State Court. Defendant's like, no, I'll get eaten alive. I want this in federal court based on diversity jurisdiction. Meaning plaintiff and defendants are residents of different state, and the amount of controversy is over $75,000. We'll cover that when we do subject matter jurisdiction. So how then does he get from California to Pennsylvania? Well, Piper moved to transfer the case of Pennsylvania under section 1404A for convenience. Then Hartzell moved to dismiss the case for lack of personal jurisdiction in California and asked for the transfer to Pennsylvania as well. So personal jurisdiction was proper in Pennsylvania in this case because that's where Piper manufactured the plane, and Piper did business in Pennsylvania. So personal jurisdiction was proper over Hartzell there too, unlike California, under the minimum context test, because again, Hartzell did business there as well. So then what happens when we get to federal court in Pennsylvania? What did Hartzell and Piper do, Attorney Cole? When we get to the federal court in Pennsylvania, what motion did they file?
Foreign non.
Yes, no, is that right? Yeah, so Hartzell and Piper filed a motion to dismiss the case under foreign nonconvenience. And I want to note that the litigation strategy of our defendants are basically first they remove the case from state court to federal court in California. Then once that case is in federal court in California, they argue that it should be transferred to Pennsylvania under Section 1404A because it's a more convenient forum. Then their third litigation strategy, once they get the case transferred to federal court in Pennsylvania, was then to file a motion to have the case dismissed based on the form of nonconvenience. They are litigation geniuses, okay? They have worked this system strategically, and that's what you will do to get this case where they want it. And so, Attorney Cannon, how does the district court rule on the defendant's foreign nonconvenience motion?
So the district court granted the motions and saying that it was, I'm pretty sure it was that it was like burdensome to the defendants to litigate there, so they dismissed it.
Granted the motion to dismiss the case, okay? So plaintiff's not happy about this, so they appeal to the Third Circuit Court of Appeals, and the Third Circuit Court of Appeals disagrees with the district court decision. Third Circuit believes that the foreign nonconvenience dismissal is not appropriate when the law of the alternative forum is less favorable to the plaintiff. So I mentioned earlier in class that there's a whole law school class you can take on choice of law. So just because I file a case in the federal court of Kentucky, based on the facts and the circumstances of the case, I still may have to, the federal court in Kentucky may still have to apply Alabama law or Ohio law to that case, even though it's being litigated here. And so that's what the court is saying. This is one of those choice of law situations. And so they believe that you should not be able to use foreign nonconvenience if, again, the law of the alternative forum is less favorable to the plaintiff, and it was in this case. So the Third Circuit reversed the case, right? The district court's opinion. So the issue in this case is whether this lawsuit, after all those gymnastics, should be dismissed under this doctrine of foreign nonconvenience. So we know the Third Circuit reverses the district court's decision. But how does the Supreme Court address the Third Circuit's reasoning that one cannot grant a foreign nonconvenience motion where the alternative law is less favorable? I think it's on page 189. Yes, on 189. So how does the court, again, address that situation?
They pretty much just say just because another forum has stricter laws, it doesn't matter. You can just dismiss it or reject the decision.
Excellent. Yes, the court tells us that making a foreign non-convenience determination requires flexibility, right? They say there's not just a bright-line rule about which laws are more favorable to the plaintiff or the defendant. Instead, we should consider the private and public factors, right? Which do grant us some level of flexibility. So we love the court here because finally, prior to this case, it was completely left up to the judge's discretionary opinion on whether or not they're going to grant a motion to use dismissal based on the doctrine of foreign non-convenience. Now they've given us criteria to look at. They've given us a framework, and that's these public and private factors. So for exam purposes and practice purposes, you need to know these factors because that's how you're going to make an argument whether or not a foreign non-convenience motion should be granted. Okay, it's based on these public and private factors. With respect to that, the court is. I guess the question is the court saying that an unfavorable change of law should never be a factor? Well, they're not explicitly saying that on the top of page 190, but they're saying it might be a relevant factor, right? Meaning if the court you're transferring it to is going to have an unfavorable outcome because of a difference in the law there. So the question is, does this case fall into that category, meaning where the remedy is so inadequate that the plaintiffs would have, no redress whatsoever? The court says no. The court says although the plaintiff may not be able to get strict liability in Scotland, and may get lower damages, they will not be deprived of a total remedy. Well, that kind of bothers me. So I'm like, even though you're telling me I can still get some remedy, I don't want to be disadvantaged. If I can get $500,000 versus $100,000, that matters to me. So I think the court, I don't like the level of insensitivity there because they're saying, it's not like they're going to get no remedy. They'll still get some remedy, but the strict liability remedy statutes in Scotland are going to give them less money. I don't like that. Attorney Cole.
Do you think that it would have been different had they had more evidence as to the actual manufacturing process? Because they didn't think they were in error and they were so fond of strict liability.
Yeah, because then you get it here in the States in a more favorable form, absolutely. But I think it matters, and I hate that the court's kind of nonchalant about it. They can still get some remedy. And so, in making this foreign non-convenience determination, of course, we'll consider a number of factors. The Supreme Court notes these factors in footnote 6 on page 188, footnote 6 on page 188. So the private factors are that you consider the ease of access to available sources of proof. You consider the availability of a compulsory process for attendance for unwilling witnesses, meaning can they compel a unwilling witness to come anyway? The cost of obtaining the attendance of willing witnesses. Might have to fly them from, was one of the witnesses somewhere in France, a resident of France, so they consider that. Relative advantages and obstacles to a fair trial. The existence of an alternative forum that will provide adequate relief. And so they also talk about private interest factors that should be considered, right? And again, these are all in your text, so I'm not going to go through them very slowly. I told you where they're located. They look at administrative difficulties for courts, meaning how backed up are the dockets in Scotland, right? They look at the interest of the local community and having a trial touching on the community's interest. Is there something dealing with Comfy Cow, where there are people in that community that died that were on that plane? The burdens of jury duty on a community which may have little or no relationship to litigation, and the interest in avoiding having courts interpret other states' laws or foreign laws, which is a big one. So if you represent the estate where Reno is, what are your arguments under these private interest factors, right? And I know we're almost out of time. I was trying to finish, but I'm not. I hate not to come back to it. So if you represent the estate, again, where Reno is, your arguments are going to say, your arguments with respect to, if you're using the public interest factors, are, you're going to say the records concerning the design, manufacture, and testing of the propeller in plane or in the U.S. is one argument you're going to make, using, again, the private factors. You also would say that the plaintiff, and I'll email this to you since I'm going fast, would have more access to sources of proof relevant to the showing of strict liability and negligence if the trial is in the U.S. On the other hand, if you represent the defendant here, meaning the plane and propeller manufacturer, the argument under the private interest factor is going to be like, hey, look, the crash occurred in Scotland, so the evidence and witnesses are located there. It'd be more expensive for Scottish witnesses to have to travel all the way to the U.S. to testify. So we know the Supreme Court ends up concluding, with respect to the private interest factors, that the court notes that before non-convenience determination is within the trial court's sole discretion. It may be reversed only for a clear abuse of discretion, right? The court also says that although private interest points in both directions, the district court was not unreasonable, right, in concluding that fewer evidentiary problems would be posed if the trial were held in Scotland, as again, a large part of the evidence is located in Great Britain. Additionally, the court mentions that there may be serious issues with forcing a third party in Britain, meaning Air Navigation and McDonnell, to come and be a part of that case. And so, if the defense can prove, the court said that there's no design defect, but that the pilots or the charter company's negligence led to the crash, then the defendants would have zero liability. And then last but not least, the court talks about the public interest factors. It essentially says that Scotland has a very strong interest in litigation. The accident occurred there, which makes sense. The decedents are Scottish, and apart from Piper and Hartsdale, all potential plaintiffs are decedents. All potential plaintiffs and defendants are Scottish. So they said there is a local interest, which I agree with, in having localized suits decided at home. And then lastly, the plaintiff argues that there's an interest in protecting American citizens from American manufacturers producing effective products. But the court says that the incremental deterrence and holding in their favor basically is insignificant. So what's important, I will cover this again in our next class, meaning I'll back up as I always do and go back over these main points. And I'll email them to you so you can, my points I was making, so you can think about it, and then tell me what questions you have. But what's important to take away from this case is that if you're trying to determine whether or not to use a form or not to use, you evaluate public and private factors that are in the footnote in the text. That's the black letter law to take away from this case. All right, so I will email you all shortly, and have a good day. Thanks for letting me keep you fresh for 3 minutes. Are you serious? Yes. Thank you. You know what? Why didn't more people say that?
I was about to go.
Let's back up. I haven't looked at one in a while. I was thinking 10.
That was right.
Thank you.
But my mind's already gone.
I know, so well, some people were packing her stuff up, and I was like, well, let's back up. See, this is good. So, no, I'm not emailing now. I'm sorry. All right, so let's back up. So, yeah, so if you represent the estate administrator here, Reno, yes. What are your arguments under the private interest factors? And what I was saying is that you would say the records concerning the design, manufacture, and testing of the propeller and plane are in the U.S., which I think is an important argument to make, right? And then second, the plaintiff would have more access to sources of proof relevant to showing strict liability and negligence if the trial is in the U.S. So if I were representing the estate, the plaintiff, those are the arguments I would make with respect to the private interest factors. Again, I would say the records concerning the design, manufacture, and testing of the propeller plane are in the U.S., which possibly could have caused a crash, right? And then you have more access, the plaintiff would have more access to resources, and sources of proof relevant to showing strict liability and negligence if the trial is in the U.S. But if I'm the defendant and I don't want the trial here in the U.S., the arguments under the private interest factors would be, look, I understand the parts were manufactured and designed in the U.S., but the crash happened in Scotland, right? So the evidence and witnesses are located there, which makes complete sense. And it would be a lot more expensive for all those witnesses to have to travel from Scotland to the U.S. So again, those are arguments that I would make if I were representing the defendant under these private interest factors. And I think those make sense. So what does the Supreme Court end up including about, again, the private interest factors? First, the court notes that in determining the form of nonconvenience is within the trial court's sole discretion, as I mentioned earlier, and maybe only be reversed for clear abuse of discretion. The court says also that although the private interest points in both directions, that the district court did not act unreasonably, okay, in concluding that fewer evidentiary problems would be posed if the trial were held in Scotland, which I agree because, again, a large part of the evidence is located in Great Britain. So you're already in Europe, you're already on that continent, you're going to have people come all the way to the U.S. I think it's important, too, when the court mentions that there might be serious issues. They say with impleading a third-party defendants. So we won't cover impleading here because it's CIPRO 1, but essentially the way that it works is, and you're not going to be tested on it, CIPRO 2, I'm just explaining it. If I'm the plaintiff, I file a case against the defendant, say the defendant has a business partner, and he's like, well, I'm guilty, he's guilty, so he's jointly liable as well. And so the defendant can file a motion to implead to force his business partner to be a part of the suit as well. And so that's what that means. So they're saying here that there might be serious issues trying to implead any potential third parties that might share joint liability if they're all located in Britain. It's very complicated when you're trying to force a defendant from Britain who was not originally named in the lawsuit to come over here and defend themselves. So that's what that means. And then the court said if the defendants can prove that there's no design defect, but the pilots or the charter company's negligence led to the crash, and the defendants again would have zero liability. And then last but not least was the public interest factors that I was racing through. And the court concluded that based on a choice of law analysis, if the case were tried in Pennsylvania law would apply to Piper, and Scottish law would apply to Hartsdale. Again, that's that class that you would take to tell you why that is. So having a trial involving, they say, two sets of law, so Pennsylvania state law and Scottish law, they got, which I agree would be too confusing to a jury. And the court lacked familiarity with the Scottish law as well. And so the Supreme Court says consideration of these factors by the district court is indeed appropriate. Imagine how difficult it would be for a federal judge trying to interpret Scottish law and then apply it when they weren't trained in that particular area. So in terms of why the Supreme Court agrees with the district court's application of the public interest factors, again, they were just basically talking about the strong interest that Scotland has in litigating the case there since the accident occurred there. It involves some of their residents in terms of eyewitnesses, and so they just really focused on the fact that there was they felt like Scotland had a local interest in having localized suits decided at home instead of here in the U.S. And so the plaintiff argues that there is interest in protecting American citizens from American manufacturers producing these defective products, but the court says again, not significant. And so the takeaway from the Piper case is we know the Supreme Court overturns the appeals court's decision and held that the district court did not abuse its discretion in granting that forum nonconvenience to dismiss. And more important, in making a forum nonconvenience determination, courts will assess the public and private interest factors noted in footnote 6. Okay, that's the black letter law takeaway. So again, in making a forum nonconvenience determination, the court will assess the public and private interest factors contained in footnote 6. The Piper case is important for you to read as well because it's designed to highlight the fact that venue can be challenged essentially in three main ways in federal court. So you can challenge it via 1404A, 1406A, and forum nonconvenience doctrine. There's three ways you can challenge venue. Again, and that's where the plaintiff initially filed the suit. Three ways. Now, when you hear all this, are you kind of surprised? Like, before I came to law school, I didn't realize. I just thought you file your case in a court and the judge listens. You might have a jury. Like, I didn't realize all of these shifts they happen in turns, and I could be forced to litigate somewhere else, and I had all these considerations, and that the state had to have personal jurisdiction over the person that I'm filing a lawsuit against. Like, I didn't realize it was quite this complicated. Is anybody kind of surprised at all the levels, or not really? It was law.
I didn't know it was weird because I knew the Dixon's
Just to file a case, like, my God, it's a lot. I mean, I understand why the rules are in place for fairness purposes, but it just seems like, and there's so much more. This is CIPRO 1. There's so many more twists and turns, but okay, now we're actually done. And anyone have any questions about the takeaway from Piper? Yes. section 1404A. Challenge. 1406A.
Great.
All right, have a good day.
I think I forgot the espresso shot in here. I just like maybe you're like immune. No, I'm not. This usually lasts me all day, and I just was like, where is it?